Hello and welcome to the February 2022 Tosca 30 for 30. Today we'll be speaking about Tosca enforcement under the Biden administration. My name is Greg Clark, and I'm a partner at Keller and Heckman in our Washington, D.C. office. I work on Tosca matters in addition to other environmental issues. Next slide, please. And I'm joined today by Tom Berger, partner in our Indianapolis office. Tom also works on many Tosca issues. Next slide, please. Our topic today, as I mentioned, is Tosca enforcement under the Biden administration. Before we get into specifics on enforcement matters under the Biden administration, it's best to begin with an overview of the enforcement authority that EPA has under Tosca. So Section 11 provides EPA's authority to inspect and subpoena companies and facilities covered by Tosca. EPA has authority to inspect or subpoena any facility or conveyance in which chemical substances are manufactured, processed, stored, or held, either before or after they're distributed in commerce. Now, if EPA is going to inspect a facility, it will typically provide written notice, although that's not required. There's a reasonableness standard if EPA is going to show up at a facility without providing written notice. Now, in general, administrative agencies have been held by the courts to be able to investigate merely on suspicion that a law is being violated, or even just to get assurance that the law is not being violated. So there's no probable cause or any other kind of threshold that needs to be satisfied. EPA has authority to inspect any facility that's covered by Tosca. Next slide, please. So Section 15 and 16 of Tosca lay out prohibited acts and penalties under Tosca. Those prohibited acts include violations of any EPA rules, regulations, orders, as well as the statute itself, as well as use of substances that are known to be manufactured in violation of Tosca. Tosca does set a maximum penalty for violations. Typically, when we're talking about enforcement actions under Tosca, what we're talking about are civil penalties. Tosca is strict liability, so there's no requirement that a violation have been knowing. But typically, we're looking at civil penalties. The maximum civil penalty was amended in 2016 by the Lautenberg Act to raise it to $37,500, as well as a provision to adjust that based on inflation. EPA adjusts these every year. The adjustment now with inflation, it's $43,611 is the maximum civil penalty. Now, there are also the potential for criminal penalties. They're much more significant. The maximum penalty is $50,000 as a general matter, and the potential of imprisonment up to 1 year. But knowing or willful violations that place individuals in imminent danger of death or serious bodily injury can create significant additional liability. Fines up to $250,000 for individuals, or up to $1 million for an organization, as well as extended imprisonment. So criminal penalties are very serious under Tosca, but as I mentioned, typically what we're looking at are civil actions, civil penalties. Now, Tosca does not include a statute of limitations, but courts have held that the general 5-year statute of limitations applies to Tosca, at least in the Section 5 and Section 13 areas, but we expect that would apply across Tosca. Now, there are violations that are termed to be continuing violations. So as a counterexample, violations of Section 5, manufacturing or importing a substance that's not on the Tosca inventory. Those are discrete violations that occur when you manufacture or import that substance that's not on the Tosca inventory. By comparison, at least at the administrative level in the elementous chromium case for those who follow these, for 8E, substantial risk issues, those have been termed to be continuing violations, where the violation continues until the required report is filed. So although a Section 8E violation would still be subject to a 5-year statute of limitations, and that at most you could have 5 years worth of penalties. That 8E violation continues until it's rectified by the company subject to that requirement. Next slide, please. Within Tosca, there are certain enforcement areas that EPA focuses on if they're going to do an inspection. Under Section 4, that would be test rules and now test orders. Section 5, it's PMNs, SNRs, LVEs, ensuring that you only manufacture and import those substances that are on the Tosca inventory and that you comply with any SNRs or LVE requirements. Section 6 is an emerging area based on the Lautenberg Act amendments and the existing chemicals program as EPA goes through risk evaluations and issues risk management rules. That seems a likely area for enforcement focus. Section 8, CDR, and to a lesser extent, inventory reset. These are areas where it's easy for EPA to determine if there's been a violation when they do an inspection and they request information from a company. Section 12, 12B export notices, another area of focus. And then finally for Section 13, import certifications. Now, typically in an inspection, EPA is not going to request all of a company's import certifications, but rather a sample so that they can essentially assess the standard operating procedures that the company uses for certifying imports. Next slide, please. Now, a key and critical part of enforcement actions under Tosca and really under all EPA statutes are what are called enforcement response policies. Now, enforcement response policies address gravity-based civil penalties under a specific statute or section of a statute. And what they do is they categorize different types of violations based on the nature, the circumstances, and the extent of that violation. And they assign to each of those categories or subcategories of violations a penalty amount, as well as characterizing the nature of it. I mentioned earlier that Section 5 PMN violations are assessed for each day of manufacture. It's a per day type penalty, whereas other types of violations, say reporting violations like CDR, are determined by EPA to be single day violations. So enforcement response policies provide to both the government as well as the regulated industry predictability and transparency in terms of how the statute would be enforced. So under Tosca, there are really 3 key ERPs. There are some additional ERPs, for example, related to the lead abatement requirements, which also arise under Tosca. But in terms of core Tosca enforcement response policies, there's the Section 5 enforcement response policy, which was issued in 1988 and subsequently amended twice in the following 4 years. There's an ERP that covers Sections 8, 12, and 13. That was issued in 1999. And finally, there's an ERP for Section 4 test rules, which was issued in 1986. Next slide, please. So let's go through some examples of how the ERP works. And so this is applying the ERPs for these individual sections, and it includes an inflation adjustment. So in addition to adjusting the maximum civil penalty on an annual basis, EPA adjusts the lower penalties that are set for each of those categories within the ERP every 2 years. And they just issue that again in January to update that for inflation. So the first example, non-reporting for the 2020 CDR. So this is a violation of Section 8. This is assigned as a level 1 significant single day penalty per chemical per site by the ERP. That level 1 significant penalty is now $29,655. And so you work that through for this example. If we have, say, 5 substances at a single site, and very quickly it adds up to $148,000. A second example, if you import a substance that's not on the Tosca inventory, so this is a violation of Section 5 and the PMN regulations. Say for this example, you imported the substance 5 times a year for 5 years. Each import was 8,000 pounds, and this was a substance that was used on the site and it wasn't further distributed or processed. And it would have been subject to a 5E order had a PMN been filed. So for going through the Section 5 ERP, this assigns it as a level 2 major violation. It's a per day violation, per day of import. We've done it for five times a year for 5 years. That's 25 days of import. That's 25 violations. A level 2 major is $34,889. So you multiply that by 25 days, and you see that the penalty works out to $872,000. So penalties add up very quickly under Tosca. And it's important to keep that in mind as you consider compliance and the company's obligations. Next slide, please. So on the earlier slide, we indicated the dates that the ERPs were issued. Clearly, these are all quite out of date at this point. None have been amended or updated in the 2000s, and certainly not since the Lautenberg Act amended Tosca. So there have been significant changes to the regulatory requirements under Tosca, as well as the regulatory environment as well. And so there are significant gaps that really EPA ought to address in order to provide direction, predictability, and transparency both to its enforcement staff as well as industry. So some significant gaps. The Section 4 ERP is focused on test rules, so it doesn't address test orders, which was a new authority granted to EPA by the Lautenberg Act, and which EPA has been using in the past 2 years and will do going forward for the existing chemical risk evaluation program. The Section 5 ERP, which is really probably the most critical because it delves into the most common types of violations. It doesn't address the updated polymer exemption rule. That update was done in 1995, changing the polymer exemption from a notification to a self-implementing exemption. The environment for PMNs certainly has changed such that nearly all PMNs receive 5E orders now, whereas at the time of the ERP, where it focused distinguishing the circumstances level between a substance that would have received a 5E order versus the majority which did not. Now that 5Es are issued, even if there's no issue with the PMN's intended use, either due to reasonably foreseeable uses by other companies, or if it's just to impose a formal PPE requirement, which would otherwise be used by that PMN submitter. You're in a scenario now where if you follow the ERP, Section 5 violations are at a baseline significantly higher level because most substances would receive a 5E order. So that's something else that should be addressed. And finally, on the Section 5 ERP, it doesn't address changes to the low volume exemption in 1995 or the creation of the low REX exemption in 1995 as well. Next slide, please. The Section 8, 12, and 13 ERP obviously doesn't address the inventory reset rule in 2017 or mercury export bans through the Mercury Export Ban Act in 2008 or the Lautenberg amendments in 2016, which added additional mercury compounds to that ban. So those are not addressed. And then finally, there's no ERP that relates to Section 6. And as we move forward with risk management rules for those first 10 chemical substances under Section 6, as well as the 20 high priority substances that are currently undergoing risk evaluations, those need to be addressed in terms of how those types of violations would fit in, how EPA would assess those. Obviously, there'll be both record keeping and then chemical control aspects to that as well. And then finally, when EPA first moved into the 20 high priority substances, there was a requirement that manufacturers of those substances identify themselves to EPA so that they could be invoiced for a percentage of that risk evaluation fee. Certainly that's not addressed, and that's an issue there. In terms of how EPA would assess that, is that a single day or a per day violation? Likely would be per day in order to avoid creating any kind of incentive for avoiding that requirement. So there are significant holes in the ERPs as they relate to Tosca as it stands today that EPA needs to address. Next slide, please. And at this point, I'll turn it over to Tom to talk more about what the Biden administration is doing.
Thanks, Greg. As Greg noted, Tosca Section 11 covers inspections and subpoenas. So let's go through that. And I'll try not to repeat anything that Greg said. So, here I say that, inspections is effectively ceased during the height of the COVID pandemic, but as you'll see some slides, that's not exactly true, but certainly inspections decreased during that time. I think as Greg mentioned, if EPA comes to inspect your site, you typically almost always have notice. They'll either send you, quite frankly, a hastily cut and paste letter or an email in advance indicating that they plan to come out and inspect your facility on a given date, usually about a month or so in the future. Back in March 2020, anyone recall what may have happened right about that time? EPA issued a rule that basically codified its inspection practices, but they did it in a rulemaking. And it covered things like timing and inspector qualifications and consent to enter and opening and closing conferences, et cetera. But about a month or so ago, EPA rescinded that rule to give itself some flexibility because, as you might imagine, under case law, EPA is bound to follow its own rules. And if something's not a rule, EPA can basically deviate from it as it so desires. With respect to subpoenas, you don't see too many of them. Quite frankly, as compared to inspections or these request letters I'll discuss here in a second. About the only thing to know here is they're very difficult to successfully challenge. These are administrative subpoenas, and about the only thing you can successfully challenge is breadth or burden. But I think that's kind of a common theme in all of these things, whether it be an inspection or information request letter, subpoena or inspection. If EPA asks for something and it would take you 6 months or 1,000 person hours to develop, they're typically open to working with you to minimize burden or staffing needs. Another thing we've seen fairly recently are these information request letters, and here's some of the language they use. Well, in lieu of conducting an inspection or issuing a subpoena, here's an information request letter. But quite frankly, if you look at the language and the information requested, it reads almost precisely like an inspection notification letter. And of course, it's not strictly speaking a subpoena or an inspection request, but of course, if you challenge it, you're likely to get a subpoena or an inspection notice. So not too much basis for challenging it. Next slide, please. Other than your standard civil penalty assessment action, which Greg rightfully focused on, you have other types of enforcement actions under Tosca. Let's skip to the second one first. Citizens petitions are not enforcement per se, but they have an enforcement flavor to them. Many NGOs, as you may know, file citizens petitions to basically force EPA to do things under the sections noted here. So they have a flavor of enforcement, but they're not enforcement per se. On the other hand, first bullet, these citizens civil actions under Section 20A are very interesting. And I say in the second bullet that they not used until recently. That's not exactly true. I think they were used back in one of the methylene chloride actions. And I think way back, 2006, circa that time, for some of the high production volume chemicals. But in any event, Section 20A allows any person to commence an action against any person, such as a company or EPA, to restrain a Tosca violation or to compel the administrator to take action. Okay. Last year, the Center for Environmental Health, or CEH, filed a suit alleging violations of the 2016 CDR rule by several companies, 3N International, I think Harwick was another one. And what CEH did is they basically went through and they compared import data to their CDR reports. And I don't know if you folks know this, but you can get on, you can get on databases like Panjiva or Import Genius, and you can basically look at what other companies, including your company in many cases, have imported into the United States. And so you can compare those data to CDR. And if you see a mismatch, at least to CEH, that suggested non-compliance, hence the Section 20A actions. So these complaints requested that the court require the companies to submit Form U's under the CDR and to conduct CDR compliance audits, and if plaintiff prevailed, to award the plaintiff attorney and expert witness fees. And there are several of these, I don't know, probably 5 and 6 in total, and they got picked up by the trade press, and they ended in various ways. Some of these settled, et cetera. So interesting to see if this comes around again with respect to the 2020 CDR, and I'll talk about that a bit in a moment. Next slide, please. No action assurances. I suspect many of you have seen some of these. A no action assurance is where EPA agrees not to proceed with some type of enforcement response. And the concern here is a perception of inequitable treatment, and also the possibility that somebody at EPA might say, yeah, go ahead and do this, or don't worry, we won't enforce. And then later, EPA tries to take an enforcement, and then you're left saying, well, hey, so-and-so told me I could do this. So those types of things. So outside of a formal enforcement proceeding, under this 1984 memo, EPA has a policy against issuing no action assurances. And these cover violations that either have already occurred or may occur in the future. That being said, these no action assurances can be used in the context of, say, a settlement of, say, a self-disclosure or a enforcement action against a single company, kind of your standard Tosca penalty action, as well as to address some broader issues. And most of you probably saw the March 2020 no action assurance for the fee rule, where EPA basically, well, the way the rule was written, it would have brought in all sorts of companies that only handled one of the 20 high priority chemicals as impurities, byproducts, and I think articles, and that was way too overbroad. So EPA tried to remedy that by issuing a no action assurance. Another big one was March of last year. Some of you on this call, I think, are familiar with this. The PIP 3.1, which is used in all sorts of electrical and electronics applications. Simply put, used a lot more in a lot more products than EPA and I think industry recognized. And so to kind of remedy what would have been significant disruption of supply chains, EPA issued this no action assurance to basically delay the ban on PIP 3.1. Next slide, please. Most of you, I think, are familiar with EPA's audit policy. It works very well for Tosca violations. Many of you on this call know that, we have, Keller and Heckman is heavily involved with the audit policy and helped dozens, if not hundreds of clients disclose Tosca violations under the audit policy. And under the audit policy, right, if you discover a violation of an EPA administered statute such as Tosca, and you meet all 9 conditions of the policy, EPA will waive all of the gravity-based penalties that Greg just talked about, the monetary penalties. A couple of conditions of the policy, though, are important in the inspection context. Condition 4, of course, says essentially, you can't use the audit policy if you know EPA is coming to inspect you. Right, so you can't get one of these inspection notification letters, then hastily conduct an audit and disclose violations under the audit policy and expect to obtain penalty mitigation. And in fact, one of the worst things you can do is disclose something under the audit policy that's ineligible for the audit policy. So I wouldn't recommend you do that. And the enforcement response policies contain similar provisions because you can't always disclose under the audit policy. For example, if well, there's all sorts of examples of things that qualify for the ERP, voluntary disclosure provisions, and not the audit policy disclosure provisions. And I think importantly, very last bullet, the audit policy applies, strictly speaking, to gravity-based penalties, and EPA retains the right to recover any economic benefit you realized from a violation. Next slide, please. Another important point is the audit policy doesn't prevent EPA from showing up on your door. So we've had this happen before. And one of the issues here is that you typically make audit policy disclosures through CDX, through e-disclosure to headquarters, and inspections and subpoenas, et cetera, typically come from the regions. So the region you may not know that you've initiated an audit or made disclosures under the audit policy. As I mentioned before, under condition 4, once EPA tells you they're coming, it's too late to use the audit policy. It's also important to note that the repeat violation provision of the audit policy is very important. And it basically says that you can't use the audit policy if you have the same or similar violation at the same site within the past 3 years. And the way you count that 3 years is it starts when you obtain notice of the violation. For example, you get a complaint notice of violation, as you can see down here at the bottom, and it ends when the later violation actually occurs. And so there's all sorts of subtleties that come with that. So it makes it very important to know, basically, when an inspection is complete. We have all sorts of cases over the years where EPA has shown up, conducted an inspection, goes away, and the client never knows whether the inspection is complete. Next slide, please. Okay, just some stats for you here. These are not limited to Tosca. And recall that EPA's fiscal year runs from October 1 to September 30, right? So fiscal 22 started last October. So here you can see self-disclosures under the audit policy. You can see the peach here are e-disclosures under the audit policy. The overwhelming majority of disclosures are done through the e-disclosure system. Only about 10 or so each year are done outside e-disclosure. You can see on average about 1,200 sites in the past 5 years have made disclosures, averaging about 600 disclosures per year, with just a slight dip in 2020. So the audit policy is alive and well. As I mentioned, we use it all the time for clients, and the audit policy works very well for Tosca violations. Next slide, please. Very briefly, in a nutshell, these are the Biden administration's priority for EPA. Now we're kind of pivoting towards the future. So I won't read these to you, but I suppose you could argue that all of these impact Tosca to one extent or another, but practically, it would seem that environmental justice, the second bullet, and PFAS, of course, are the most relevant to Tosca. So now let's pivot, next slide, please, to Tosca specific priorities. These are enforcement priorities for AWICA under EPA's National Program Guidance, or NPG, and these came from a presentation EPA made last September. And you look through these sections, and I know what you're thinking. Where's section 12, right? Because this covers everything that Greg just covered. 4, 5, 6, 8, 13. Those are the sections of kind of the core substantive sections of Tosca. Well, if you look at the NPG itself, it actually covers section 12. So don't think that section 12 is not a priority. I read this slide in this presentation as saying that basically everything is on the table with respect to being a priority for enforcement, with PFAS probably standing out as something that's particularly concerned to EPA. Next slide, please. Just a couple things very quickly. I think within the past week or so, EPA put an enforcement alert on certain PFAS chemicals used on skis. I guess that's timely with the Olympics. You can look at those and you can pull down the complaints if you'd like to see them, or the settlements at least. As I mentioned, at least anecdotally, we've seen an increased emphasis from EPA on economic benefit recovery and unwillingness to reduce penalty amounts. That being said, EPA often does, to their credit, allow you to explain, hey, EPA will say something like, hey, we're going to, we propose to take action against the following violations, but let us know if you think there's any reason we shouldn't do that. But if you want to obtain significant penalty mitigation outside the audit policy, you typically need to litigate, because EPA follows the ERPs and the amounts in there pretty closely. Next slide, please. If you receive a EPA inspection letter, it's going to look, quite frankly, a lot like the way they used to before the Biden administration, and quite frankly, before the Lautenberg Act of 2016. So the time frame of information that EPA focuses on is typically 3 or 5 years. It depends on the specific request and the type of information EPA is seeking. EPA frequently now is requesting process flow diagrams. Sometimes they're only those diagrams that are existing, which could reduce some burden, but that could be a significant burden on some companies. And EPA wants their typical list of substances that you manufacture, import, processed, exported in the past 3 or 5 years. A lot of the information is focused on CDR. R&D has been a focus for 30 years, probably. They want lists or copies of the Tosca submissions you've already made. And they frequently request dates or quantities, say, of chemical imports. And that amount of detail can be difficult to obtain. And EPA typically asks some questions about HC Charlie, D David, and E Edward, and the language is kind of sometimes ambiguous and kind of varies. And they typically want information before they show up. and certain information during the inspection, and you can typically negotiate submitting some of the information after the inspection. So not a big change in the types of information that EPA is requesting during an inspection. Next slide, please. Just some stats. Again, I'll go very quickly. You can read them yourself. Again, this is not limited to Tosca. You can see quite a dip in inspections in 2020 and 21. Roughly 3,200. That's still a lot, right? Think of that. 3,200 roughly inspections. If you look at the right side, they're in blue. Those two bars. 3,200 inspections in fiscal 20 and 21. But you have to remember too that at least fiscal 2020, at least half of that was pre-pandemic. And remember, you can compare these numbers to roughly 600 disclosures per year during the same time period. Next slide, please. Again, kind of self-explanatory here. Civil enforcement, again, a little dip in 2020, but enforcement, we can tell you is alive and well. Last slide, since we're kind of running on time. So just to summarize, you need to be prepared for an inspection or an information request letter. Needless to say, you need to pay particular attention to PFAS, high priority chemicals, and other chemicals kind of interest to EPA. You need to watch imports, particularly in light of the Section 20A actions. We might see similar activity from CEH for those. Always consider Tosca compliance auditing. The audit policy is a powerful tool, as we mentioned. And I think the very last bullet could be the most important bullet of the whole presentation. That is, if you want a no action assurance, if you want authorization to continue doing something, a critical chemical, it is very difficult and time consuming to get that from EPA. They don't like doing it. They've told me, I don't know if this was on the record or off the record, but they do not like doing no action assurances. So, that's another reason to do a Tosca audit where you can give yourself some flexibility. So I know we covered a lot. I know I spoke quickly. I hope you found it useful, and I hope everyone has a great day. Thank you.